Hi, my name is Carly Koza. I'm a current first-year law student at Case Western Reserve University School of Law, and we are here today with Professor Pollis for Faculty View at CWRU. And Professor Pollis, a recent New York Times article shared that Judge Polster, a United States District Judge of the United States District Court for the Northern District of Ohio, will preside over 3 consolidated Ohio lawsuits in what is known as a bellwether or test case. Can you explain what effect this may have on future cases that deal with the opioid crisis?
Sure. Let me first say that bellwether trials in general are a device that judges use when they're consolidating many cases for disposition simultaneously, and they want to try to get parties to settle. They'll hold what's called a bellwether trial to signal to the other parties who are not involved in that trial what the likely outcome of a trial that they are involved in might be. So it's called a bellwether, I think, because sheep used to carry bells around their necks or something, so you could sort of tell where the sheep were going if you knew which one had the bellwether on it, and that's kind of the same idea. In this instance, the bellwether trial is scheduled for October, but it has been scheduled before and has not gone forward when it was supposed to. So whether it goes forward as it is supposed to in October remains to be seen. There have been some developments in the litigation that might cause it not to go forward. But if it does go forward, then the result of that bellwether trial will be a verdict that the other parties in the cases that are sort of sitting on the sidelines and watching, they will take that verdict to heart and potentially use that as a basis for trying to resolve all the rest of the cases after they see the results of the first bellwether.
Interesting. And what effects has Ohio faced due to the opioid crisis?
Well, Ohio, like many other parts of the country, many other states and local governments, has spent significant amounts of money dealing with what is indisputably a national public health crisis involving individuals who become addicted to opioids. It sometimes starts with legitimate prescription use opioids and then moves to street drugs if the patient becomes addicted. And one of the worst possibilities is that in moving to street drugs, opioid-addicted patients or individuals can sometimes move from heroin, which is the typical street opioid, to fentanyl, which is much more dangerous and deadly. When you have such a large number of citizens who are afflicted by the same kinds of addiction disorders, then you as a governmental entity, whether it's the state of Ohio reimbursing for Medicaid expenses or individual cities and counties who are expending more in first responders and community awareness and so forth to combat the opioid crisis, all of those expenses are expenses that they claim they have incurred because of the behaviors of primarily the manufacturers and distributors of legal prescription opiates.
And why did the Judicial Panel on Multi-District Litigation choose Cleveland in particular?
That's a great question. We're never 100% in the know about why the Judicial Panel on Multi-District Litigation does what it does. They chose Cleveland presumably because it was fairly centrally located. It is in the heart of an area where opioids have been a problem. And they chose Judge Polster in particular, who is one of the judges on the Northern District of Ohio, because he is familiar both with multi-district litigation generally, he's handled them before, and also he has been very successful in getting very difficult cases to settle. And if there's any aspect of this that offers the possibility of settlement, I think everybody would be very happy with that.
Why could drug companies have an upper hand, but why should we not count out plaintiff at trial?
That's a great question. It's very difficult to know how this case is going to come out. As an initial matter, drug companies are being sued for creating a public health crisis. And that is really an unusual kind of claim to be made. We've seen it before, for example, when the tobacco companies were sued, but we've never seen a public health crisis of this magnitude, particularly given that the cause of the crisis, that is the product in question, an opiate, is actually has a salient purpose. Doctors prescribe it because there are some patients for whom that kind of treatment is the only way to get meaningful relief from pain. So unlike cigarettes, where there's really no salient purpose to the product, In the case of opioids, there is. The difficulty comes in because all of the expenses that the states and counties and cities are looking to recover are rather attenuated. And by that I mean it's very difficult to pinpoint precisely who is responsible for the need, for example, for greater first responder training. Whose fault is that? You can say it's the responsibility of the opioid industry or the drug industry that manufactures or distributes opioids, but how much do you ascribe to each player? It's a very difficult thing to do. It's also very difficult to connect the dots between the need for these kinds of community resolutions to the problem and the conduct of the manufacturers in the first place, because not everybody who's opioid addicted became so as a result of legally prescribed drugs. So it's a very, very difficult situation for plaintiffs to prove causation and damages. At the same time, if it gets to the jury, the evidence is going to be so persuasive about the conduct of the opioid industry, particularly Purdue Pharma, which is the biggest manufacturer, and the known problem in our communities that jurors who have a chance to award money in a case like this may very well be of a mind to do so.
And you kind of answered this throughout the interview, but what role do states play to help achieve a global settlement?
Well, you have to remember that the opioid cases are primarily brought by governmental entities. Those include states, counties, cities, Native American tribes. Any governmental entity that claims to have expended resources in order to combat the crisis is theoretically in the same situation as the folks who have decided to sue. There are about 1,600 or 1,700 different suits all across the country. Most of those suits are consolidated in the multi-district litigation that's pending before Judge Polster. But several of them, primarily involving state attorneys general suing on the behalf of their states, are in state court in the home state. And the challenge then is, how do you achieve a global settlement when you don't have all the players at the table in front of one judge? And so as an example of that, we recently saw that Purdue Pharma settled with the state of Oklahoma in a case that's scheduled for trial in May. It's the first case scheduled for trial and the first significant settlement. And that would suggest then that the proximity of trial is really the thing that got Purdue Pharma going in terms of wanting to try to settle. But the problem in terms of global settlement is that you really can't achieve much unless everybody's at the table. And Judge Polster in the multi-district litigation does not have the jurisdiction over the states to bring them to the settlement table.
Thank you. That was my final question. So thank you so much for your time today, Professor Pollis.
My pleasure.